Morning.
Sir, can you please state your name?
Anthony Alfaro Callejas.
All right. What are we doing today on these?
Your Honor, we're,
I also reached out, we have a discovery, technical issue that we're trying to resolve, so I wanted to put you on the head entertain. I believe, we are requesting an adjournment. I did extend an offer, which he has, discussed with his client, and they're still considering that as well.
that is correct, Your Honor. We're waiting on a little bit of discovery left over. We would ask for this to be reset. And also, when we're done, I'd like to make an amendment to the bond that you granted at the last hearing.
Probable cause conference, August 14, 2025, 9 a.m. As to bond.
Your Honor, you granted home confinement at the last hearing. My client has went to that location. It is quite a distance from where he's working. He has a friend that lives much closer to where he works. I think it's about 15 minutes away. It's a walk for him. And I provided an amended bond order that I sent over to your office, also to the prosecutor's office, so they could see that as well. There's the new address of, I believe it is 4822 Washington Avenue, Unit 15, Ann Arbor, Michigan, 48108. So we just asked that you would amend the bond to allow him to reside at that address for work purposes.
Any objection?
Okay.
All right, I will sign your order on that, counsel.
Thank you, Your Honor.
All right, thank you. Bond will continue in all other respects.
Thank you. Have a nice day.
All right, you too. Hold on now. Court does call the case, People versus Marvin Sullivan.
People.
Morning, Your Honor. Michael Vincent on behalf of Andrew Sullivan. Hey, good morning.
Your name, sir?
Mark Sullivan.
All right. Good morning, Mr. Benson.
Good morning, Your Honor.
You're requesting an adjournment?
Yes.
Oh, somebody's here with you. Good. How much time did you need?
A lot. Just for the court's information, over the night, we received 700 pages of a report. And more to, I believe, we're picking up even more information from Pittsfield. My comment would be cooperative with discovery. The court should know that.
I can, the 19th, which is a Tuesday, or the following week, 28th, which any objection from the people?
Okay.
Probable cause conference will be adjourned August 28th, 2025, 9 a.m. Bond in this case will continue. Court does call the case of People versus Amar Amadou. Amar Amadou? Who's on this? Shocking, it's canon. Hello. Welcome.
Thank you, you were very.
No. That was wrong on.
I messed up. Okay. Stephanie Cannon, on behalf of Mr. Amadou, keep your hands out your pocket. Your Honor, Your Honor, I am going to ask for an adjournment, and I will.
Are you?
Yes, yes, a 2-week
Took you
adjournment.
that long to
case.
decide?
I had to discuss something with my client, Your Honor, that's
Just did
all.
that now.
Yes.
Okay.
Yes, that's the thing, yes.
How much time did you need?
I'm requesting a 2-week adjournment.
Are you?
Yes, please.
I bet you I don't have a green sheet.
You do not,
You are
Your
looking
Honor.
all around for one. One's not gonna magically appear. We'll wait. Not long. August
I'll do one, Your
14th,
Honor.
2025, 9 a.m. Bond will continue. That's okay. Mr. Brown was filling one out for you, but
I appreciate it. I will get done, Your Honor.
thank you. Hey, they're bringing more? We don't have enough? What? Court calls the case of the people versus Mario Amison.
Alexander, on behalf of the people, Your Honor.
Robert, on behalf of Mr. Amison, is approaching the podium. Amison, please state your name for the record. Mario. So cute. So, Your Honor, there's a date and time set for probable cause conference. I was recently appointed. However, we are asking, I do not believe that there is video in this case, so we are asking that the matter be set for preliminary exam.
And if I could address Bob, feel free, Your Honor.
Why am I not shocked? Okay. So you believe you have all the discovery?
I believe so, Judge.
Would the people have their witnesses available to 12?
We'll do our best, Your Honor.
Preliminary examination, August 12th, 2025, 9 a.m. That is before Judge Freshour. Yes, as to bond.
Your Honor, it's come to my attention that Mr. Amison has called the victim in this case 100 times since his arraignment. So at this point, I would be asking.
What, 100 times?
100
Hold on,
times.
let me
Okay.
Let me talk.
So I would be asking that his phone privileges be revoked. It's her listed number in this report as well.
Response?
So, Your Honor, I spoke with Mr. Amison in the jail recently. We went over the no contact.
That wasn't on the phone, was it?
No, Judge. it was-
Kidding.
well,
My bad. Go ahead.
technically it was, Judge, because it was through the glass. So we did have a discussion on it. I explained that the no contact order, even if he receives contact from the complaining witness, he's not allowed to respond. Or to, I don't know, I got it. Or if he is, even if she wants contact, it's my understanding that she does want the no contact order lifted, but we did explain what it means to have a no contact order in place. And going forward, I'm confident he will not be making any more contact and reaching out to the victim at all.
Excuse me,
Just-
can I
just-
talk,
just-
man?
What do you want to say?
She came and visited me, man. They let her come visit me, so it couldn't have been that serious of a non-contact.
So, we did discuss what the no contact order means. And so at this point, we are asking we're already set for preliminary exam. So, and the.
Say no domestic violence or nothing, man. It's a fraud case.
We got it. It's my understanding that the complaining witness has reached out to him several times, and so that he didn't really understand what the no contact order meant. We've explained it. We've hammered down that no contact means no contact. So that at this point we are.
Well, let me ask this then. Other than those times where the defendant's alleging that the victim has come toward him, are the phone calls his calls out to her?
Your Honor,
Some are from his pin and some are from other pins.
Well, I understand that, Mr. Burdell, there might be a mix-up when she
Excuse
comes there and
I got one more thing to say, man. You ain't wearing it right, man. Excuse me, can I talk? I know how to talk. You feel me? I got you. She came
sure,
to,
go ahead.
she came to the jail to visit me.
I heard you.
I haven't seen nothing, and mail said no contact. She able to visit me if it's a no contact order, and I'm in jail.
That I don't know, and that's why I asked if there were, I'm trying not to take those contacts where she's making them with you into consideration, because your attorney just explained that you had a conversation about how you have to respond to that.
Then they
So
took,
then I asked, were there phone calls from or contact from you to her, which would be strictly prohibited?
right. Well, I was under the impression that I wasn't able to have no contact upon my release. They said during bond, we can't be in the same household. They never said about calling her from jail. This is not no domestic violence issue. This is a fraud for $30. That she clearly called the prosecutor and said she didn't want to press charges.
I don't know any of that, sir.
Like,
I don't.
because they telling you half the story, man.
I'm not gonna get that information right now. I'm not supposed to have that information right now. Anything else, Mr.
No, Your Honor.
Anything else, Mr. Bedell?
No, Judge, not at this time. Thank you.
At this time, and this is only for the calls that he's making now, either from his own pen or from other pens, because that is not allowed and strictly prohibited. Defendant's phone privileges at this time are revoked. You can make the argument before Judge Freshour to reinstate them after the preliminary examination.
Judge.
Thank you, Your Honor.
Thank
Man,
you.
you fired, man.
What'd you say?
Come talk to him, Mario.
You just want me to go? You don't want me to go? You want me to stop on that and say something? You just want me to keep going? Really? Okay. All right. Let's go. I'm gonna pick up the next one and just. This is on your advice, because I got something to say. But I'm not going to. Court calls the case, People versus Nathan Bell.
Maybe Rich, we good for the people.
Assistant Public Defender Cosimo Movesi on behalf of Mr. Bell, but not with Mr. Bell. Nathan Bell? I have no explanation at this time. I had been in contact with him yesterday.
You were?
Yes.
How'd that go?
He wasn't on the bus, but we were gonna be asking for an adjournment, Your Honor. I have no explanation for.
Bench warrant, 10,000 cash surety. The warrant will issue immediately.
Thank you, Your Honor.
Thank you. I feel better. Thank you. Always looking out for me. Court calls the case, People versus Virgil Dunlap.
Corey Burton Harris, Assistant Prosecutor appearing on behalf of the people.
Your Honor, Edward Dukas on behalf of Virgil Dunlap.
All right. Your name?
Roger Dunlap.
Good morning, sir.
Your Honor, there's some outstanding discovery that I'm looking to collect. I'm asking for a few weeks to review everything. There are 2 different matters and search warrants and lots of reports, so I'd be asking for possibly the 28th of next month.
Is he held on anything else?
He is being held. I also have supplied the court with a consent order for a release to treatment and a
I
reduction.
signed that.
Okay. Nothing else is holding him.
Any objection to the 28th?
No, Your Honor.
Probable cause conference, August 28th, 2025, 9 a.m. And will continue.
Thank you, Your Honor.
Thank you. Court does call the cases of the People versus Robert Galett. See in, yep. Got it.
Introduction of any for the people. Bob.
Asa Bashir for Robert Galett on matter.
Oh, I'm sorry.
Thank you.
Good morning, Rob Duke on behalf of,
Could you state your name, please?
Robert Gallant.
Okay.
Judge, I apologize. Ms. Reiser, may I approach with her sheets?
Here now. You request, both of you are requesting an adjournment.
Yes, Your Honor. We're still working with Avalon, trying to get housing. We have phone calls in the works, Robert.
And we'd request, it's possible to have a 1-week adjournment. I believe Mr.
If it's got to be 2 weeks, she's going to cover for me. I have a circuit court trial.
Someone from my office, Mr. Yeah,
What?
There's a trial. Mr. Killawalt has a trial in 2 weeks, so it'd be possible that.
Why don't we see what date he's picking, adjourn it?
Probable cause conference, August 14th, 2025.
Go with that.
9 AM, bond will continue.
Thank you, Judge, for
Thank
your
you.
understanding.
Court calls case of the people versus Malik Wallace.
Ally Zen on behalf of the people, Your Honor.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Wallace. Mr. Wallace, could you please state your name for the court?
Malik Wallace.
Your Honor, we're asking the court to please set this for exam.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available to 12.
We'll do our best, Your Honor.
Preliminary examination in person will be set August 12th, 2025, 9 AM. That is before Judge Valvo. Bond will continue.
Thank
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Eduardo Benavides.
Victoria Burton Harris, she's the assistant prosecutor appearing on behalf of the people.
No, I'll wait. Eduardo Benavides.
Be conversing with the client on one last matter was coming up.
There was an issue that came up. I'd ask,
There was an issue?
yes, sir.
Is that Miss Akinruli? That-
Yes. It's, yeah. No, she's not,
Oh, she's not the issue?
she's not the issue. Never.
Where is she?
never.
Oh! Your Highness.
Good morning.
They were talking bad about you. I had
Not
you
Mr.
covered.
Brown, though.
Yeah, oh no, Mr. Brown was saying the worst stuff. He said you had issues. That's how I heard it.
You shouldn't.
Apparently they didn't finish. the
Assistant Public Defender Chinad Akinruli, Your Honor, on behalf of Mr. Benavides. Mr. Benavides, state your name for the record, please.
Eduardo Benavides.
conversation. Thank you.
Judge, we're asking for an adjournment today.
All right. Will the 14th work for you?
That should be fine,
All
Judge.
right. During the matter, August 14th, 2025, 9 AM, bond continued.
Thank you.
Thank you. That's called the case of the people versus Brandon Bowman.
Ally Zen on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Carson Lewis on behalf of Mr. Brandon Bowman, who's present to my right. You state your full name for the record, please.
Brandon Charles Bowman.
Today's date and time set for a probable cause conference. At this time, respectfully requesting you set this for an exam.
And if I could address bond, Your Honor.
Are you going to address the conditional bond violation report that we have? There's something else?
Yes.
Oh, lovely. All right, you want it set for exam
Yes, Your Honor.
and you have the discovery.
To my knowledge, yes.
Would people have their witnesses available to 12?
We'll do our best, Your Honor.
Preliminary examination in person will be set August 12th, 2025, 9 AM before Judge Fresh Hour. As to bound.
Your Honor, I believe the defendant is in custody on a no contact order of bond violation originally. after he was put back into custody, he's tried to contact the victim 21 times. None of the calls have been successful, but he has tried to call her listed number in the police report. Since being put back in for violating the.
And at this time, what's his bond? Is it revoked?
I have it as denied, Your Honor.
Yeah, that's what it should be. All right. As to that,
Your
Mr.
Honor, I haven't seen anything about these calls. My client is saying that he's,
I have not made one phone call.
Your Honor, he's gonna be asking for a PR bond. He's been in for 8 days.
Is the phone calls that he made, is that attached to his pen?
Your Honor, I'm trying to pull it up my internet thing now.
Okay. I understand you're saying that none of the calls were completed, but were they made from his pen? That's what I'm trying to figure out. Well, why don't we do it this way? Mr. Robesi, you can talk to the prosecutor's office regarding that. If they did come from, I'm gonna, at this time, I'll revoke his phone privileges. I will reinstate them if they did not come from his pen. Okay, so get with the prosecutor's office and I should have that answer as soon as their internet goes back up. All right, sir? All right. Otherwise, bond will continue as denied.
Your Honor, we have it pulled up.
Oh, you do have it? Hold on.
They're from different pins.
They're from, are any of them his?
No, they're all different pins. There are 2 different pins that are being used, but not this.
And none of the calls were connected?
Correct.
All right. I'm gonna deny the request then to have his phone privileges revoked at this time.
Your Honor, my client is asking for a PR bond. He's been in for 8 days. He just,
I have a conditional bond violation. That's why he's in.
I understand. He's willing to admit to the bond violation and ask for the 8 days without a hearing if.
That I would not be sentencing him to the 8 days on it. for
Understood.
bond. I can tell you that. So does he still wish to admit to the violation? Yeah. Well, that's okay. Yes. I'm gonna need one. Forget about that.
Okay. Okay. Understood, Your Honor. Then we'll keep it as it is.
Sorry. Once I check your history. I'm just a figurehead. Clerk calls the case, People versus Anthony Miller. He's in.
Your Honor, Alexis Pluma appearing on behalf of Mr. Miller.
Mr. Miller, can you state your name, please?
Anthony Lavelle Miller.
Thank you.
Your Honor, I am going to ask to address bond first, if you would allow it.
It's gonna have to be brief.
Okay,
Otherwise, you're gonna have to file a written motion, show back up at 4.
okay, understood. Briefly, Mr. Miller's bond was originally set because he failed to appear for a hearing last fall. I do have proof here that Mr. Miller at that time was incarcerated in the Wayne County Jail. He was in from September 2024 to April 2025. He would like you to consider a personal recognizance bond on his behalf because he has a part-time job.
How did he
and
come back into custody?
I believe he was picked up.
So he didn't
from-
walk in after
from-
he left his time in jail?
He was in Wayne County, then taken to Oakland County, then transferred here. So he was released from Wayne County at the end of April of this year, then went to Oakland and then was transferred here. So he was not out of custody at any point in time.
That's what I'm asking.
Yeah.
Said he was picked up.
Picked up from another jail It's, I guess, what I
Oh,
meant to,
okay.
meant to say. And he would be staying at the Delonis Center if released, but he does have his sisters who live in the area.
Any response from the people?
Your Honor, in the court's discretion, starting the retail bond, so, he's in custody. This isn't his fault. I mean, retail bond.
What was his previous bond set at?
He had a personal recognizance bond prior to failing to appear last fall.
Why do we have 25,000 cash surety? Well, doesn't matter. I'll grant that motion. I'll set his bond at $25,000 personal recognizance bond previously declared.
Understood. And Your Honor, I do have a green sheet for him. We're just requesting a 2-week adjournment.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Bond continues. Thank you.
Thank you.
Case People versus Robert Carl.
Your Honor, Alexis Kumar again on behalf of Mr. Carl. Mr. Carl, could you say your full name?
My name is Robert Martin Carl, something.
I have before me a plea form that the defendant is going to be pleading to guilty to account 2 of use of cocaine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
All right. May I have him sworn?
Okay.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth? So help
I'm
you
sure
God?
I do.
State your name.
My name is Robert Martin Carl.
All right, sir, it's court's understanding you're going to plead guilty to the charge of use of cocaine. That's a misdemeanor, punishable by up to 1 year incarceration and a $1,000 fine plus court cost.
I want to be accountable for that, sir. Yes, sir.
What?
I want to be accountable for that, sir. Yes, sir.
Okay, so you understand the maximum penalties in the charge?
Maximum should be a year.
Will be up to 1 year incarceration, a $1,000 fine plus court costs. You understand that?
Yes, sir, I do.
All right. And understanding that, do you still wish to plead guilty?
Yes, I do, sir.
All right. You understand also, sir, that I will not, while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that, sir?
I never know that, but okay, sir.
All right. Did you want to discuss that further with your attorney?
My attorney.
You're gonna be sentenced in Ypsilanti.
Mhm.
Judge Barr, that's where all your other cases are.
Mhm.
So Judge Simpson's not gonna send you. Come back with me, Ypsilanti.
Or we'll just do it here.
Everything. Yes, sir.
All right. You want to proceed?
Proceed.
All right. So to that charge, how do you plead?
Plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
That is correct, sir.
All right. You signed an advice of rights form. Is that correct?
I did, yes, sir.
Okay. You have any questions regarding any of those rights?
No, I appreciate your consideration, and I'm accountable for the thing.
Okay. I need you to look at paragraph 5 on that form. You'll see a copy on the podium there. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir, I understand clearly.
You understand you're giving up your right to appeal of right.
That'd be part, yeah, no.
You understand that?
Yeah, I take that, yes.
All right. Are you on probation or parole?
That's incorrect, sir. It's hard no, sir.
Okay.
I mean, no.
Okay, I'll try that again because I want to make sure the record.
No,
is
sir.
clear. Are you on probation at all at this point?
No, sir.
Okay. Are you on parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No promises made that I did not.
All right. Has anybody threatened you or coerced you in any way?
No, sir, they haven't.
You're doing this voluntarily?
This is the,
Okay, you're doing this of your own free will?
Yes, sir, that's correct.
All right. And you're also doing it because you believe that you're guilty of this offense, sir?
I am.
Okay, all right. On the date of March 27, 2024, at the location of 220 Pearl Street, City of Ypsilanti, Washtenaw County, State of Michigan, were you in possession of cocaine?
Yes, but no. No, yes, I was. I just go with that. But yes, I was.
Okay, let's try this again.
Yes, I was, sir.
Okay, let me ask the question. On the date that I just mentioned and at that location,
Yes, sir.
did you have cocaine in your possession?
Yes, sir.
Well, did you?
Yes, sir.
Okay, did you use the cocaine?
Given a chance, I would have.
Okay, so you didn't use it.
I did use it. I was using cocaine. I had cocaine and I was using it.
So you did use it?
Yeah,
Okay. Did you know what you were using was cocaine?
I was very advanced on that information. Yes, sir. Yes, sir. Keeping it simple.
So, sir, if any of what I just say is incorrect, let me know. On that date and at that location, you had cocaine in your possession, you used it, and you knew it was cocaine. Is all of that correct?
That is all correct.
Thank you. All right. Now, sir, I have to advise you that if between the time of this plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rule, you would not be entitled to withdraw your plea, nor would the judge be bound by any evaluation in this case. You understand that, sir?
Yes, sir, I do. Correct.
All right, counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
All right, and have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Defense is also satisfied, Your Honor.
Court will accept the defendant's plea to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be August 13, 2025, 10 a.m. before Judge Barr.
And Your Honor, very briefly, if the court would consider a personal recognizance bond now that Mr. Carl has pled, he does have just recently got his own home in Ypsilanti through a VA housing voucher, and he is concerned about potentially losing that housing if he stays in custody. He does know what he would need to do in order to get out, and this is the only case that's really holding him. He does have other cases out of 14A2 with low nominal bonds set. He could afford to post those, but not the bond on
I'm
it.
going to leave that choice up to, I'm going to deny the request at this point. I will leave that to Judge Barr, who will be able to take everything into consideration regarding this gentleman. So your motion for bond reduction is denied at this time.
Understood. Thank you.
Court calls case People versus Jerry Bigham. So it must have been, he must have been at the time.
Andrew Bannister. Councilman Basie on behalf of the defendant, Your Honor.
Jerry Bigham, don't bang on my podium. What are we doing?
Yes, Your Honor. At this time, my client is wishing to waive his preliminary exam and seek an offer in circuit court.
Sir, is that correct?
Yes.
Do you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed?
Yes.
Thank you, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution?
Yes.
People also waive the right. Preliminary examination having been waived, defendant bound over to circuit court on both counts. Mr. Belvis.
Your Honor, we acknowledge the information. Thank you. At this time, my client waives formal readings and stands mute to the charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
September 18th at 1:30, Judge Slay.
September 18th, 2025, 1:30, Judge Slay. Bond will continue.
Thank you, Your Honor.
Court does call the case of the people versus Sean Dorsey.
Andrew Childers, on behalf of the people.
Morning, Mayor Mike Getty, Assistant Public Defender on behalf of Mr. Dorsey, who's here to my right and beat me here by a mile. State your name for the record.
Sean Dorsey.
Your Honor, this is the first PCC. We are requesting a brief adjournment so that I've had a chance to speak with Mr. Childers so that we can continue to discuss this matter. We're also going to see if we can't work a release to treatment in this case.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Bond continue.
Thank you, Judge.
Thank you. Court does call the case of the people versus Michael Boyce Smith.
Good morning. Thank you, Vice Chair. On behalf of the people. I believe this is.
Yes, it's Miss Atkins release case once again.
She was just reviewing the
What, she's reviewing what? Video?
video of it, and she couldn't get it open, but ours open.
Oh, was she in with, were you in with your client reviewing video?
I was, Your
You've
Honor,
had
but
quite a week.
it's, I have, you know.
Yeah, I know.
Yes.
Because all of it's happened in front of me.
We've been
It's
together.
been a
all
mess.
week.
I'm surprised you're still standing.
Just hold it together, Judge. Try it. Good afternoon. No, it's still morning. Good
It's still
morning, Your
morning.
Honor.
Yes, it is.
Assistant Public Defender.
You want me to pass it so you can look at?
No, it's okay, Judge.
Okay.
Yes.
What would you like to do?
We would like to adjourn this matter. The court should be in receipt of a green sheet.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Bond
Thank you,
continue.
Judge.
Thank you. She's had a day. It's only been 2 days, but.
And I had a docket after we left.
What'd you say?
I had a docket after we left till 6:30 yesterday.
Did you? You are my hero. Court calls the case, people versus Robin Finney.
Andrew Childers, on behalf of the
And good morning, Your Honor. Laura Yagi, Assistant Public Defender with and on behalf of Ms. Finney, who is standing to my right. Please state your name for the court.
Yes, Robin Lee Finney.
All right.
And Your Honor, I am hopeful that we will be able. Oh. I did send over pretty substantial mitigation, including this newspaper article about all the work my client's done in the community to Mr. Childers. So he is reviewing that and I think gonna have a conversation with his witness. So we're asking for a brief adjournment.
Probable cause conference, August 14th, 2025, 9 a.m. Bond continue.
Okay, August 14th, we'll be in touch. Good luck. Thank you.
Court calls the case, people versus Savannah Bradley.
Corey Burke, prosecutor of your own county.
And Laura Yagi, Assistant Public Defender with and on behalf of Ms. Bradley, who's approaching. In terms of the substance, the PCC, Your Honor, we're requesting an adjournment. Ms. Bradley is very eager to get into treatment. We have spoken, unfortunately, she works a lot, so we played some phone tag. I do want to address the bond issue.
So do I.
Yes. So initially, when I first spoke with her, she indicated that she was not aware that it was such a tight time frame within 24 hours of her release, that she was expected to do an intake. She
Sure.
followed up with them and she did make contact with them, scheduled an appointment. Unfortunately, she didn't realize it was the same time as a psychiatric appointment she had. So she went to her psychiatric appointment and then she was basically calling them and calling me, waiting for them to call her back. There was a misunderstanding there. I think it was 2 days ago or yesterday, I told her, just go, don't even wait for them to call you, just go. And she was at work and she wasn't able to get there before they closed. So I did tell her first thing this morning to go, but by the time they opened, she was already here. And so we are asking for the opportunity for her to go test today or for her to check herself in.
But after that point in time, she had no further contact with them.
So she is saying that she did call them repeatedly after the 23rd. I know that's not in their report, but that is what she is saying, is she called them and she left.
Very clearly says she failed to report for her intake appointment as ordered. No further contact has been made.
I understand that's what they say. She's saying she tried to call them. Her dad is with her in court today.
So, and when she tried to call them, what'd they say to her?
She left a message, I think.
And nobody called her back?
That's what she's saying.
Really?
I just want to make two other points. So first, she is a working mom. She is a 9-year-old. I believe she's sole care 9-year-old, right?
If she went over, would she test clean?
I don't know. I think so. I mean, based on my conversations with her, I will also
I
say,
think it's like a clearest question one can ask.
okay, she's saying she would test clean. And she's saying she is prescribed to Adderall and that's what she would test for.
And that's the only thing that's gonna show up?
Should, yeah,
Will or should?
will,
That's it.
yes.
I tell you what I'm gonna do. I'm gonna give you a shot. She needs to go over right now to community corrections, do her intake, take her test, and if you could let them know she's on her way over. If anything, tell them also that if anything comes, you need to come back over here. But if they get the test before you get back over here and something else shows up, take her into custody.
Understood. She is prescribed that medication, like I said, but
I heard.
understood, Your Honor.
Get over to community corrections. I'll pass the matter. Court calls case people versus Matthew Fonseca.
Good morning, Your Honor. Public Defender Carlson Lubez on behalf of Ms. Fonseca, who's present to my right. Can you state your full name for the record, please, Matthew?
Matthew Fonseca.
Thank you.
Your Honor, today is the date and time set for probable cause conference. At this time, we're respectfully requesting to step for exam on both matters.
Discovery is complete.
To my knowledge, yes.
People have their witnesses available to 12. Preliminary examination, August 12th, 2025, in person, before Judge Valvo, in both matters. Bond will continue.
Thank you, Your Honor.
Court does call the case, people versus John Altcock. Yes.
Stephanie Kane on behalf of Mr. Occult, who's appearing by Zoom. Mr. Occult, could you please state your name for the record?
John Paul Alcott.
Your Honor, at this time, we are asking that this be set for a preliminary exam.
Discovery is complete.
To my knowledge, yes.
And would the people have their witnesses available to 12? Pardon?
That's fine.
All right. Preliminary examination in person, August 12th, 2025. 9 a.m. before Judge Freshour.
Thank you, Your Honor.
Bond continue. Thank you.
Thank you.
Court does call the case of the people versus Nathan Gubachi.
Requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Ron Brown.
But you thought you had to be right next to her and not in the room?
Where you want me to leave?
Yeah. No, it's always a pleasure seeing you, Mr. Brown.
My pleasure, sir.
All right, so you just stay right there. All right, that makes me happy. All right, what are we doing on this case? Permission to practice it.
Thank you, Your Honor. We're requesting to adjourn this matter awaiting medical records for our office to receive his medical records.
His medical.
Yes, Your Honor.
I mean, I could put it out 2 weeks since he's in custody, but I don't, how fast are they?
May we approach? Prosecute.
Yeah, come on. Came up, that was what it's gonna end up being. Oh, what'd you say? I got it.
January 10th, he was found not competent but able to regain competency. January 30th, competency hearing, a 90-day review set. April 11th, 90-day review report, still not competent. May 1st, competency hearing set, 90-day review due to competency update. July 3rd, competency hearing adjourned to allow 90-day review. And July 14th, update from Forensic Center, no update. Defendant refused to speak. I'm asking, he has grandparents who are interested in his well-being. I'm asking for some type of bond so he can get out of jail. He's been in there for months. It's a stalking, aggravated stalking charge, a 5-year felony. But he's been in there for months now. So I'm asking for some type of bond that can be worked out.
Well, I don't really need a response because I might consider a bond if he were cooperative in the process, but I mean, I can understand, his grandparents. Certainly they're concerned, but if he's not cooperative with this process while in custody, I'm not clear how that's gonna happen if he's out of custody and we can't do anything.
I will contact the grandparents, see if some inroad can be made there.
All right. So what I will do is I'll have to, I mean, do they need a new order to see him? Do we know?
I can check one moment. I don't believe so. I recall reading that they felt like, in their opinion, he remained incompetent until they learned that he worked.
Got it. Well, right, his status would remain as it was on the original finding, so. Well, let's do this. I'll adjourn the competency review hearing. It's my last date in September, because he's got to see somebody and then a report. I'll set the review date to September 25th, 2025, 9 a.m. If we get a report before then, certainly we can move that date up.
Thank you.
Okay, thank you. It might say he was giving me a party. Court calls the case of People versus Jordan Hartmeyer.
Assistant Public Defender Natalie Pate with him and on behalf of Mr. Jordan Hartmeyer, please state name for the record, sir.
My name is Jordan Hartmeyer.
Thank you, Your Honor. To my understanding, discovery is complete and I have reviewed and discussed that with my client. At this time, he is wishing to set this case for preliminary examination.
Would people have their witnesses available to 12? Preliminary examination in person will be set August 12, 2025, 9 a.m. before Judge Valvo. Bond will continue.
Thank you, Your Honor.
Okay. Court does call the case of the People versus Deontay Clifton.
Edward Dukas on behalf of Deontay Clifton.
Mr. Clifton, can you unmute and state, oh, there you go. Can you state your name, sir?
Deontay Clifton.
Thank you.
Thank you, Your Honor. There's some outstanding video that I'm looking to obtain. I'm asking for an adjournment. I am also now on the approved list, so I can speak with him up in the Newberry facility.
Okay.
I have court with him next week, so certainly I will have contact with him by then, but it's been about 2 weeks since I've been able to have contact with him, so.
All right, you want the 19th then?
I'd prefer if we could go.
I can do the 14th, but that means, are you gonna be able to get everything you just said done?
I don't think by then. I'd prefer you had said which date?
Well, I can do the 19th or I can do the 28th.
I'd ask for the 28th.
28th. Any objection from the people?
Objection.
Probable cause conference, August 28th, 2025, 9 AM bond will continue.
Thank you, Your Honor.
Okay, thank you. Thank you,
Can I
Mr.
talk to
Cliff.
you for a second, please?
You can give me a call. I'm on your approved list now.
Court calls case, People versus Robert Jameson.
Andrew Childers.
Asli Bashir on behalf of Robert Jameson is approaching. And,
Your name, sir?
Robert John Jameson II.
Thank you.
Your Honor, we're requesting the earliest available preliminary exam date,
All discovery is complete.
to our knowledge.
People have their witnesses available to 12. Preliminary examination in person will be set August 12th, 2025, 9 AM before Judge Freshour. Bond will continue.
Your Honor.
Thank you.
Court calls case of the People versus Lester Braggs, is it?
Michael Gaddy, Assistant Public Defender for Mr. Braggs. Believe he's on Zoom, Judge.
Mr. Brett, there he is. Can you unmute and state your name, please?
Lester Braggs.
Thank you.
Your Honor, we're asking for a brief adjournment in this matter. I believe we have it resolved. It's a matter of posting some restitution. I'd ask the court for 2 weeks to accomplish that.
2 weeks, he'll be able to do that.
Yes, he'll be able to post it in 2 weeks.
Exactly. Probable cause conference will be adjourned August 14th, 2025, 9 AM. Bond will continue.
Thank you, Your Honor.
Thank you.
I'll be in touch, Mr. Braggs.
Okay.
Thank you. Court does call the case People versus Chad Jones, all 4 of his cases.
And Laura Yagi, Assistant Public Defender with and on behalf of Mr. Jones, state your name for the court.
Chad Jones.
And Your Honor should have a STIP and proposed order to release to treatment in his 4th case, which is the newest one. It's the first PCC for that case, even though it predated his arrest. He's been in custody for the past several
In
months.
his
but,
4th case, which number on that?
the number is apologies, Your Honor. It is the 25 F5 5162.
Okay, I do see that. I'll sign off on that. That I don't have a problem with. All right. And then you want this, you're seeking an adjournment of these proceedings?
Yes, Your Honor.
How much time? I mean,
I think, I mean, he's going to court in Canton in just a few minutes to ask to be released to treatment on that hold. So hopefully a couple weeks, but I
can do the 14th or 19th.
I guess the 14th. Thank you.
You're welcome. August 14th, 2025, 9 AM. Bond will continue.
Thank you, Your Honor.
Thank you. Calls the case of the people versus Dominic Brewer.
Andrew Banner.
Assistant Public Defender Jay Bellinger on behalf of Mr. Brewer who approaches. Mr. Brewer, can you please state your name for the record?
Dominic Brewer.
And Your Honor, I just got good contact information from my client who was recently released from a different county, so I'm just asking for some time.
Probable cause conference, August 14th, 2000. Well, why don't we do August 19th, a Tuesday,
Thank you, Your Honor.
2025, 9 AM. On continue.
Thank you, Your Honor.
You, sir. Court does call the cases of the people versus Vincent Lambert. No, no, wait, no, go ahead, I'm sorry.
Like Fatima appearing on behalf of Vincent Lambert.
Your name, sir?
Vincent Lambert.
Thank you.
Your Honor, at this time, we are requesting for adjournment. We are awaiting discovery for 2 of the cases.
All right.
It's all right. I'm okay with bonding over at Monkey right now. Okay. I'm just trying to speed it all up.
Mass, yeah. Your Honor, we would like to address bond when appropriate.
Briefly, I will. Probable cause conference in these cases will be adjourned to August 14th, 2025, 9 AM. All right, Esteban.
So we'd like to modify the bond to reflect a similar bond by Judge Conkey in circuit court.
What?
Like to modify the bond to reflect a similar bond to what Judge Conkey has ordered in circuit court for treatment.
Okay, so I'm supposed to guess on that, or what was it?
And Judge Conkey's courtroom, he's allowed to be released to treatment. He's on probation in those cases. And
So he can be released on a PR to treatment?
yes, Your Honor. The people wouldn't have an objection to a release to treatment if there was a tether. We do have some concerns. Mr. Lambert does have multiple cases in front of this court. Defense counsel and I have been emailing back and forth and I think there's some more coming. But
More what coming? Cases?
Yes.
Oh, boy. So, do you have an objection if he's on a tether? Don't ask Brown. Do you have an objection
No,
if
we
he's
don't
on
have
a
an
tether?
objection. No.
Don't? Okay, so I don't have any objection to release to treatment for anybody. You guys just include the tether language in and somebody will sign it. I mean, I'll sign it.
I have a question.
Sure.
When being released with tether, they require for you to have a phone. Is that going to be a requirement for treatment as well, even though I'm being released to treatment? Because you can't have a phone in treatment, but I don't have a working
Correct.
phone.
And that may be, so let me put it this way. If you have the tether and you guys can work it out, I'll sign the order either way. But that may limit his options of treatment.
No, I'm saying that I don't have a working phone in my property, and tether, the last time I was released, required for you to have a phone before you can.
Correct.
Okay.
And so that's gonna cause a problem for you. But somebody may be able to solve that problem. The other problem that is caused is some facilities do not allow the tether and then do not allow the phone, which you would have to operate. Everybody got that? Okay, so he can be released to treatment on a PR. And I'll sign that order. I don't have a problem with that. And so his bond will continue with that modification, so, okay?
Okay, thank you, Your Honor.
Court calls the case People versus Anna Bowman. He's what?
Your Honor, Alexis Plumey appearing on behalf of Mr. Bowman.
Mr. Bowman, can you state your name, please, sir? Yeah, Mr. Bowman, can you state your name?
Need to talk to my lawyer.
Pardon?
Need to talk to my lawyer.
He
Mr.
doesn't
Bowman,
apparently want to state his name or follow the orders of the court. Go ahead.
I didn't hear you. I'm sorry. I didn't hear you. Dr. Adam Baldwin.
thank you. And Your Honor, I do have a green sheet here. We are requesting just a brief adjournment, and Mr. Bowman would also like me to address his bond if you would allow
Well, we
it.
started out on the right foot for that, but go ahead. Take it your best shot.
Understood. Mr. Bowman is currently being held on a $50,000 bond on this case. This is the only case that is holding him currently. He is asking the court to consider a personal recognizance bond. He doesn't have a history of failing to appear for court. He does attend all of his hearings. And primarily, his request is because he's currently enrolled in school at Wayne Community College, and is worried that he is going to default on his loans if he remains in custody, and also worried that he wouldn't be able to get another loan in the future because of this. He would stay away from the University of Michigan Hospital as well, which is where he was seeking psychiatric treatment when this incident occurred.
Response.
The people would request a bond remain as currently set. It's on it, it's on the sex offender registry, exposed himself to staff at the hospital. There's in a lot of very explicit threats to staff, including threats of sexual assault, violence against them. Very well maybe related to mental health issues. Those are clearly not currently in checks.
Anything else? Mr. Bowman?
No, Your Honor, thank you.
Motion for bond reduction is denied. Bond will continue.
Thank you.
Thank you.
Now, what was the next court date?
14th. Trick question. Yes, 14. Case of the People versus Alicia Cargill.
Children's grant on behalf of people.
On the splits, she's listed as a PD contact, but I don't know that the. I don't think there's Hightower Brown's office.
So I don't have,
So the PD is the attorney of record currently.
because I don't have it.
So Lauren Brown, Deputy Chief Public Defender. I believe that we determined that this is a conflict for our office.
Ms. Cargill?
Yes.
Okay. Hang on one second, but I don't have an order nor an attorney for Ms. Cargill.
We've sent it out. I think Mac is probably working on appointing someone. Do you want me to send someone down there and have? them-
Yeah, but well, we don't have.
I've spoken to Ms. Hightower Brown. I don't believe she has what she.
She's coded.
No, it is a conflict.
She went now. She's co-defendant. Okay, so she's a co-defendant in a case where we already represent with Anitra Coomer.
Right, but I get it, but I have no paperwork.
Okay. So
do that. The co-defendant's case is set for what time? 12:30 this afternoon, but I can't do that with.
Right. Do you want us to?
Do you have any, do you know what you're gonna be doing on the co-defendant case at this point? What?
I believe she's entering a plea.
Okay, so it may not matter what I do here. All right. Ms. Cargill, here's what I'm gonna do. Okay, right now, there's a conflict with the public defender's office. I don't know if you were overhearing that conversation.
Yes.
Okay, so I usually get an order down with a new attorney appointed, so I can tell you who that is. I don't have that. So what I'm gonna do is I'm gonna adjourn your case out 2 weeks, because even if I had an attorney, they're gonna need to talk to you. So I'm gonna adjourn your case out 2 weeks, which is the fastest that I can do it. we'll get that order down today signed and there'll be an attorney that will contact you, okay?
Okay.
All right, very good. So probable cause conference will be adjourned to August 14th, 2025. 9 a.m. Bond will continue. All right, thank you, Ms. Gargo. Court does call the case, People versus Nicole McCauley.
Asli Bashir for Nicole McCauley.
Nicole McCauley.
Thank you.
Thank you. And Your Honor, we have a green sheet.
All right,
We're requesting a brief adjournment just to confirm some information for further negotiations.
August 14th, 2025, 9 a.m. Bond will continue.
Thank you.
Court calls case of the People versus Xavier Briggs Sumner.
Asli Bashir on behalf of Xavier Briggs Sumner.
Xavier Briggs Sumner.
And Your Honor, we are requesting an adjournment to review discovery in this matter, media discovery that we didn't.
Probable cause conference, August 14th, 2025, 9 a.m. Bond continued. Court calls case of the People versus Urbima Magbury. Oh, Jerry.
Assistant Public Defender Chinazi Carriac Naruli on behalf of Mr. Averma Magbury. Mr. Magbury, state your name for the record, please.
Thank you. I have before me a plea form that indicates that the defendant would be pleading guilty to the charge of use of cocaine count. Upon his acceptance of that charge, count one would be dismissed. The prosecutor will recommend and have no objection to the sentence. The defendant is currently under VOP sentence by Judge Conlon and will be in the Washington County Jail until November.
That is correct, Your Honor.
All right. He has signed off on this. Did you mean to check the sentencing judge waiver box?
I did mean to check that.
Pardon?
Is it checked?
No.
Yeah,
That's why I asked.
I intended to check it.
Did
Your
you?
Honor. I
Okay,
did.
and I'll do that for you.
I appreciate that so much,
All right.
Judge.
May I have him sworn?
Ryan, you solemnly swear to the testimony about the guilt to be the truth, the whole so help you God.
I do. All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of use of cocaine. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that? You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced in the 15th District Court before Judge Valvo. You understand that? All right. Now, understanding all of that, you still wish to plead guilty? Yes? And to that charge, how do you plead? I mean, to that charge, how do you plead? Guilty, not guilty? Guilty? Now, you understand that by pleading guilty, you'll not have a trial of any kind? Yes. You signed an advice of rights form, is that correct? I did. Any question regarding any of those rights? Please look at paragraph 5. Those are your rights. You'll see a copy there on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form. Yes. You understand you're giving up your right to appeal of right? Yes. Are you on probation or parole? No. Has anybody promised you anything other than what's been stated here today on the record to get you to plead? No. Anybody threaten you or coerce you? No. You're doing this voluntarily? Yes. Of your own free will? Yes. And because you believe that you are indeed guilty of this offense? Yes. June 23rd, 2023, at the location of 900 South Maple, City of Ann Arbor, Washington County, State of Michigan, Did you have cocaine in your possession?
Yes.
Did you use it?
Yes.
Did you know what you were using was cocaine? All right. Sir, I do have to advise you that if I accept your plea and between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rule, that you would not be allowed to withdraw your plea and any sentence or recommendation or evaluation by the court would no longer be bound by. You understand that, sir?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements
No, Your Honor.
that have cost? You want to let me finish? You want to go ahead? That was your way of sort of preemptively saying that you're not aware of anything else.
We are not
All
aware
right.
of any other things.
Are the people aware of any threats, promises, inducements that have led to this plea?
People are not.
All right. And have I complied with the court rule and would it be proper to accept this defendant's plea?
And defense is satisfied as well, Judge.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Sentencing in this matter will be August 26, 2025, 9 a.m. before Judge Valvo. Bond will continue. Thank you.
Thank you, Judge.
She said that so nice. It's not like Ann. He's on June, Judge. Court calls the case before versus Anthony Turner. I'm gonna let her know.
Thank you, Richard McDuffie. People.
Stephanie Can on behalf of Mr. Turner.
It's all just a surprise sometimes.
I couldn't hear you.
Yeah, it's okay. No, I'm just.
I couldn't hear you.
Mr. Turner, can you state your name, please?
Anthony Turner.
Thank you, sir.
And Your Honor, we have actually reached a plea in this matter. However, they didn't bring my client over, so I couldn't get him to sign the plea form. Your Honor, if it's okay with the court and okay with my client, I'd ask that I be allowed to sign it with his permission.
No, I'm not gonna do that. The plea form
Yes, Your
and
Honor.
everything.
It's
has
all
he-
right here, Your
Has
Honor.
he read it?
We discussed it last week, but
Did you go through it in detail with him?
I could not, Your Honor. They did not bring my client, so no, Your Honor.
Well, where is he?
He is currently,
He's downstairs.
yeah, he's downstairs. I can go downstairs if you want to call it maybe later today. Is that okay?
Oh, no, that's not happening.
Oh, well, there's that.
There's,
So there's that. There's that. Your Honor, I went to the jail to see him prior to getting the plea form.
I know,
So I'm
I
sorry.
get it.
Okay.
I get it. And you weren't able to get that and go through all of his rights and go through everything with him. I
That's-
prefer that you do that. I will, although I don't want to, I will give you just a 1-week adjournment. Is he
Perfect.
held on anything else?
Nope, Your Honor, it's just this. He's going to
It's
mental
just on
health.
this one?
Yeah, he's going to mental health court. He's already been, it's all right here.
It's all been, okay, so let me do this. Let me kick it out 1 week.
No, it's not. Pay attention.
Thank you, Your Honor. What's the date you're turning it up to?
2025.
You see, he wouldn't let me borrow his pen. I'm
What?
like, you see how he wouldn't let me use his pen?
You didn't bring your own?
You know what, Your Honor?
Bond will continue. All right, thank you. Thank you, Mr. Turner. She'll be down to see you and go through those forms with you, okay?
Yeah.
All right, thank you, sir. Court calls the case, People versus Lawrence Buckner. I don't know why you thought you were gonna get support here for this.
Alexander, on behalf of the people, Your Honor.
Yeah, the assistant public defender for Buckner was in the courtroom, Your Honor, making his way to the podium.
Oh, there.
And if you read it.
Lawrence of the family of Buckner.
Your Honor, we'd like to set this matter for a preliminary examination.
Discovery is complete.
To the best of my knowledge, Judge.
Here, thank you. People have their witnesses available on the 12th. Preliminary examination in person, thank you. Will be August 12th, 2025, 9 AM. That is before Judge Valvo. Bond will continue, and I might suggest that before his preliminary examination, that he's properly attired or appearing before Judge Valvo. Thank you.
Yes, Your Honor, thank you.
Court does call the case.
Here.
People, Brenton Morrison.
Andrew Sugar, appearing on behalf of people.
Really? Can she stay in the courtroom or no? She's coming.
Assistant Public Defender Chinazi Carey Akinruli, Your Honor, on behalf of Mr. Britton. Mr. Britton, state your name for the record.
My name is Britton Morrison, sir.
Thank you.
Mr. Morrison.
Mr. Morrison. Britton Morrison.
Yeah, it's okay. Okay, you would have known that had you been in court.
You are
But that's okay.
right. Judge, we're requesting an adjournment. We're in negotiations with the people. The people would like to know a little bit more about my client, so I want to get some mitigation information together for him.
Will the 14th be enough time for you to do that?
I think that's
Okay.
fair.
August 14th, 2025. 9 a.m. Court calls the case People versus Dorian Bulow.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Bulow, who approaches, Your Honor. State your name for the record.
Dorian Bulow.
And Your Honor, my client has been tendered an offer. The offer is contingent upon him paying significant restitution. I'd be asking for 3 weeks at this time.
Pardon?
I'd be asking for 3 weeks at this time.
Okay, so I have like 2.5 weeks or 4.
Okay, I think
So-
if, I would prefer 4.
Work that.
Thank you.
Any objection from the people in that regard? Probable cause conference then will be adjourned August 28th, 2025, 9 a.m. Bond continue.
August 28th, let's say then, okay? We'll talk.
Okay, thank you. Court calls case People versus Melvin Morrow.
If you were to make people.
Or Yagi, Assistant Public Defender, with and on behalf of Mr. Morrow, who is approaching. Mr. Morrow, can you say your name for the court, please?
Melvin Morrow Jr. Thank you, sir.
And Your Honor, I apologize. This one I didn't submit before the docket started. In terms of the substance, the PCC, we are requesting an adjournment. I just emailed Ms. McDuffie this morning about a piece of discovery that I think would be relevant. I would ask to address bond if possible.
August 14th, 2025, 9 a.m. Briefly, go ahead.
Yes, Your Honor. So Mr. Morrow is here because he missed court just last week. I believe it was just last week that he missed court. He was unfortunately not aware of his court date. He said he was released from the jail without papers and he doesn't have a working phone, but he gave us his case manager's phone number. He's going through an eviction right now. And so things have been really tough. I did talk with him and have a very serious conversation that if he needs to check in with the court every single day, he will do so. So he doesn't miss another court date. I believe this is the only case that's holding him right now. Is
it?
That's what XGL is showing. Yes, it's just showing this case. When I met with him last night, he indicated he's willing to have on a tether to alleviate flight risk concerns. GPS tracking tether. He's
Are we
really
sure it's his only case? Only because the bond initially was set at a nominal amount, which leads me to believe that he had something else.
so he does have a case pending before Judge Kunke, but it should be a personal bond. And so XGL is showing this as the only case that's holding him in jail.
But does anybody know what the bond is before Judge Kunke?
I'm looking right now, Your Honor. My last recollection was that, and let me just confirm this real quick, because I don't know. Yeah, Your Honor, there was a bench warrant issued in that court too. However, he was told that he could do a walk-in on the warrant at any time before Judge Conkey.
Has he done that?
It was for a failure to appear. He has not been able to do so yet because I wasn't able to get a hold of him, so.
So how did he come back into custody?
I believe, oh, he said he was, getting off the bus in Ypsilanti, heard the officer calling his name. Or, I'm sorry, Ann Arbor. So the officer knew him. So I don't think there's any new allegation of criminal
But he didn't turn himself in.
activity. That's correct. Your Honor.
And he didn't appear before Judge Conkey.
So that's correct. He was, my information from him was that he was in the hospital. And so he's had some health issues going on. He's had a lot of family members pass away recently and he's been evicted, going through that process. So he's had a lot that he's been juggling. But
At this time, I'm going to deny your request and then you can certainly bring it back before the court once Judge Conkey rules on his and he gets before her.
Understood, Your Honor.
Take another look at it.
Okay.
Bond will continue. Thank you. Calls case People versus Kevin Burden.
Assistant Public Defender Jay Bellinger on behalf of Mr. Burden. Mr. Burden, can you please state your name for the record?
Kevin Burden, sir.
And Your Honor,
Waiting response for the mitigation packet.
that is correct, Your Honor. We're still working on that. I think 2 weeks would be sufficient if that works with the court.
Probable cause conference, August 14th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you.
I just letting you know that. I'm just pointing out facts. Court calls case People versus Stefan Wainwright.
Oh, it's unmuted. Hey, Your Honor, before my attorney speaks, I want to change something. Because I
Want to do what?
want to change something. So I signed yesterday to have my preliminary exam waived, which I don't want. We actually spoke about an insanity plea thing, and I wanted to move forward with that because I am insane and I was looking to get help.
Hey, well,
Hey,
all right, Judge.
go ahead. What? All right. Thank you, Mr. Wainwright. Yeah, go ahead.
Student
You.
Attorney Kara Rosenkranz requesting permission to practice under Michigan Court Rule 8.120 under the supervision of APD Hannah Apple on behalf of Mr. Wainwright.
That is the first time you've done it reluctantly. But permission to practice is granted.
Thank you, Your Honor. I suppose we'll be requesting an adjournment in this matter.
All right, Mr. Wainwright, here's what I'm gonna do, because obviously you did something with your attorneys before, and I thank you for pointing that out. I'm gonna adjourn your case out so they can talk with you a little bit more about what exactly is going on right now, okay?
Thank you.
You're welcome.
Thank you, Judge.
Probable cause conference, August 14th. Will that be enough time or you want the 19th?
14.
Whatever's. Oh, he says 14.
Okay. But given what he said, is that who I should be listening to? Never mind. Don't answer. August 14th, 2025, 9 a.m. Bond will continue. Thank you, sir.
Thank you. Have a good day.
Now, Ms. Cannon, you should make that admission sometime. Court calls the case, People versus Brian Ginyard. Gerard, excuse me.
Andrew Childers appearing on behalf of the people.
What? They're not at the door. He's in custody. Let's go to this next one. Court does call the case of the People versus Maurice Burgeons.
Victoria Burke Harris, Chief Assistant Prosecutor, here on behalf of the people.
And Laura Yagi, Assistant Public Defender, with and on behalf, hopefully of Mr. Bergens. Mr. Bergens, can you unmute yourself and state your name for the court?
You have to be here first, right?
Yes, I was talking with his partner, who I had thought was logged onto Zoom earlier. I would ask if the court would consider briefly passing so I could give him a call. Or waiting until the end of the day to issue the warrant. Please, Your Honor.
Bench warrant will issue bond 10,000.
Your Honor.
Just listen.
Okay.
Just. No, go ahead. You now interrupted.
No, I'm sorry.
No, go ahead.
I was just gonna ask if I'm able to get in
Because
contact.
Bishop
with
was
him.
appalled. Go ahead.
If I'm able to get in contact with him, and I have an explanation for what's happening by the end of the day, would the court consider recalling the warrant?
Yeah, but I didn't finish, so I was gonna do that. But Ms. Yagi can't. Thought I might do something really good.
That's not how you like your stickers.
I do. I put the sticker on already. Thank you, ma'am. Did I get to the bench warrant part before she interrupted me?
I will be honest, I
Oh,
don't know.
don't know. I'll start over. Bench warrant will issue for defendant's failure to appear bond to set the amount of 10,000 cash surety. Ms. Yagi, that warrant will not issue until Monday, the 4th.
Thank
So
you.
now you have nothing to say, right? All right.
Now I would say thank you. Thank you, Your Honor.
Court calls the case of the People versus Brian Gerard, 2 cases.
Rich Childers, attorney on behalf of the people.
Michael Fatima appearing with and on behalf of Brian Gerard. Please say your name for the record.
Brian Gerard.
At this time, we are waiving to circuit court for global resolution.
So he's waiving on both of these cases.
Yes.
All right, sir, is that correct?
But yeah, yes.
All right, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
So I'm doing right now is waving. Yeah. I didn't know any of that. Yes.
All right. You understand you will not have that hearing on either one of these cases and that you'll proceed to circuit court for further resolution.
Yes.
And that's what you want to do, sir?
That's what I got suckered into yesterday. Yep.
Okay. People also waive their right on these cases.
Yes, sir.
Preliminary examination having been waived in both cases, defendants bound over on the single count in each one.
Yeah, you guys said no president.
Counsel, you acknowledge receipt of the information waiver to reading? Or not? You're not listening. Go ahead.
We acknowledge the receipt of the information and we waive its formal reading and the client will stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. A pretrial in this matter will be set for
August 11th at 1:30 with Judge Hughes.
August 11th, 2025, 1:30 before Judge Hamud.
I'll be there.
We'll provide the transportation. Bond will continue. All right, sir, thank you.
Thank you, Your Honor.
This one, just like this one. They need to go. So then they can sign off on the thing. So just do that other one, hand those to Alan so he can take over. Court does call the case, people of the state of Michigan versus Michelle Campbell.
Thank you, Rich. Make it for people.
And Assistant Public Defender Jay Bellinger on behalf of, but not with Michelle Campbell, Your Honor. I made several attempts to get a hold of her. I know in talking with Ms. McDuffie, we were planning on adjourning this matter. I would ask for that. I understand she had some health problems last time she was here, so my concern is for that at this time.
That she had what?
She had some health issues last time she was here. So I'm concerned about her well-being at this point. I have not been able to get a hold of her.
Why are you rooting for him? People have any objection to an adjournment?
No objection.
Really? Finally, the first case, you're gonna be cooperative. Never mind.
If you-
Never mind, never mind.
I have some available.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m.
Thank you, Your Honor.
Bellinger, if she doesn't show, I'm taking you.
Yes, sir.
All right.
Thank you. I know you have a whole arsenal, so.
I sure do.
Court calls the case, people versus, is it Ibid Timmy Abuzula?
Alexander on behalf of the people, Your Honor.
And Stephanie Cannon on behalf of Mr. Abguzulu, who is to my right. Could you please state your name?
Vitimi Alexander Gunzulu.
Okay, what are we doing?
Your Honor, we're just asking that this be set for a preliminary exam.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available on the 12th. Preliminary examination, August 12th, 2025. 9 AM before Judge Freshour.
Your Honor, my client is wanting to know whether or not the court would kindly allow him to have his calling privileges back. He understands that he should not have made any calls. He will not be doing so in the future, concerning the complaining witness.
Your Honor, I would object at this point, given the nature of the calls and why his phone privileges were revoked. I would ask this to be something that could be addressed at exam, given that he was trying to have third parties reach out to the victim. So I would ask that that his privileges stay revoked at this time.
Anything else?
Nothing, Your Honor. Thank you.
All right, I will deny the defendant's request for modified bond. Phone privileges will remain to vote. So. Call the case, people versus Kamani Hamilton.
For the people.
Good morning, Rob Dickel on behalf of Mr. Hamilton. Monty, can you state your name for the record?
Monty Hamilton.
Judge, I've had a chance to speak with him. We set an exam in this matter, Your Honor.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 12th.
Judge, I have a trial that day. We make it the week after.
Oh, that's right. So the 19th.
That's possible.
Preliminary examination, August 19th, 2025, 9 AM. It's in person before. It's actually will be at noon, 12 noon, and that's before me.
All right, thank you, Judge. Monty, I'll come and see you.
Continue. Thank you,
Judge.
sir. Court does call the case of the people versus Stefani Cash.
And Public Defender Natalie Pate with and on behalf of Ms. Cash, who is present via Zoom. Ma'am, can you please unmute and state your name for the court?
Cash, you have to unmute.
Tiffany Cash.
All right.
Thank you, Your Honor. Your Honor should be in receipt of a green sheet. I am respectfully requesting an adjournment. I did discuss this matter both with my client and the people. We believe we're missing some photos from discovery, so we are asking for an adjournment to get those.
August 14th, 2025, 9 AM, bond continue.
Thank you, Your Honor. Thank you, Ms. Cash. That's for today.
Thank you.
Case people versus Abdel Osmond. Okay.
Only again, Your Honor, Constable based on behalf of Ms. Rafi Mohsen Osman, who is present to my right. Can you state your full name for the record, please?
Abdel Mohsen Osman.
I heard it. That was perfect.
Exactly.
Your Honor, we're going to be requesting the briefest of adjournments. We just need discovery. He was recently arraigned, so we did put in the request. We're just awaiting.
August 14th, 2025, 9 AM, bond will continue. So you'll wake up. Close the case. People versus Antonio Cornelius.
John Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Cornelius. Mr. Cornelius, please state your name for the record.
Antonio Cornelius.
Thank you.
Your Honor, today is the date and time set for the probable cause conference. I've had a chance to speak with the prosecutor in this matter. Both agree that mental health court referral is the most appropriate. So we'd like to adjourn this matter while we get that referral going. I think what the amount of time, 3 to 4 weeks now.
To get the whole,
Yeah.
because you got to get the screen, okay.
Right.
Any objection from the people? August 28th, 2025.
August
And-
28th.
Yes, sir.
All right, thank you
Fine,
very
we'll
much.
continue. Thank you.
Yes, sir. Thanks for waiting. It's been a while.
Court calls case People versus Glenn Pennington.
Andrew Childers appearing on behalf of the people.
Possibly Bashir on behalf of Glenn Pennington. Mr. Pennington, if you would say your full name.
Oh, Glenn Pennington.
And Your Honor, we're requesting a brief adjournment, just to make sure that we can get some medical information for Mr. Pennington.
Said medical?
Yeah, for negotiations and also to potentially
Are you-
address bond.
Okay, I get that, but are you trying to retrieve that from a health facility, healthcare facility?
Yes, yeah, we need to get some our release signed.
All right. Now, adjourn this probable cause conference to August 19th, 2025, 9 a.m. bond continued.
Thank you, Your Honor.
Right, thank you.
Yeah, the way you said
Court calls the case People versus Donald Wentz.
Andrew Childers appearing on behalf of the people.
Oh, she showed up.
Possibly Bashir on behalf of Donald Whitsett. And Mr. Whitsett, if you could say your full name for the court.
Donald Deontay Woodson.
Thank you.
And Your Honor, today's the date and time set for probable cause conference. My understanding, and you can correct me, Mr. Childers, I'm wrong.
Your Honor, there was, Mr. Whitsett had some cases pending in front of Judge Demuth in the circuit court. There was ultimately a resolution on those that was supposed to include a disposition on this. This case basically was authorized kind of in the error, it was supposed to not have been charged. So people would be moving to dismiss this case.
No objection to that.
No objection, Your Honor.
Case is dismissed. We'll need a nollie. All right. Thank you, sir. You're all set.
Okay.
Court calls case People versus Garrett Pentago.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Finagle, who approaches. Can you state your name for the record, please?
Garrett Pinagle.
He's waiving preliminary.
He is waiving preliminary examination, Your Honor, and at the appropriate time, I would just ask to address bond.
All right, sir, you're waiving your right to have a preliminary examination in this case?
Yes, sir.
And you understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed?
Yes.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution?
Yes.
People also waive the right.
Andrew Childers appearing on behalf of
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of information. We have formal reading, stand mute at this time.
Defendant every way from a reading standing mute, court will enter a not guilty plea. Before I set the pretrial, go ahead, argue bound.
Your Honor, my client has been entered into the sobriety or the recovery court in the circuit. He is an individual who would benefit greatly from that. However, I am asking for an opportunity for him to be released in the interim on a SoberLink device. I have talked to Mr. Childers about that, who didn't seem to have a problem with it. And I asked that for reasons. There are some underlying safety concerns in the jail that have been brought to my attention regarding my client. And I can provide to the court that he does have a place he can stay in Whitmore Lake with a family friend who has been present for him in court every time that he's had to court.
Any response?
Your Honor, the people leave it up to the discretion of the court. I would not have an objection provided that Mr. Bill's on either Silver Link or Scranton.
Is he with Judge Conkey's court currently? Is he in that program?
I don't know if it's gonna be on, I believe that might be on Judge Slay's track, Your Honor.
Got it. Okay, so, but I guess what I'm saying is he in the court, the sobriety court?
Yes, he has been accepted.
He's been accepted, okay, and that's Judge Slade? Oh, gotcha, okay. All right. What happened? Did he not show up for me or something? How did he end up in custody? Because I have his original bond, bond was denied. Did we have, we've already had a violation, haven't we?
Your Honor, I believe, my understanding, if I recall correctly, was that he did not come at a certain point. He was an earlier FTA on the case.
Yeah, this was in.
Well, no, there's a community corrections violation.
I remember something from March.
Yeah, so here's my problem. I would have. I'm gonna deny the request because I have a previous community corrections violation from March. And then at some point, he also then failed to appear.
Okay.
So while I'd be inclined to do it, given that, I'm gonna deny the request for any modification of bond. His bond will continue.
Oh, we're waiting on a date.
All right. And so then in custody, pretrial date will be set
August 12th at 1:30 for Judge.
August 12th, 2025, 1:30 before Judge Conkey.
Okay.
Thank you.
Thank you, Your Honor.
Court calls case People versus Mario Crawford. And we reached.
Stephanie Cannon on behalf of Mr. Crawford. Happy this time. Oh, you know what?
Am I gonna need that?
Mr. Allen, take this one too. This is the other one.
These are late ones. Oh, Scott and then Crawford. Why can't you? What?
That was difficult. I was like,
What was it? Is this the one you didn't turn in that you're not trying to turn in?
yes,
Is that it?
yes.
What took so long? That was like hours ago.
Shinaza.
Okay, so that one goes into a file that's probably long gone. All right, so we're back on Crawford.
I'm just requesting an adjournment. He's in.
Why you?
He actually is no longer in custody. He was released.
When I talked to him, okay,
What?
nothing.
You said, no, you were about to yell at Ann. Go ahead.
No,
Let's see how
I
that
would
works.
never.
No, you were about to, Ann said something, you were like, I mean,
That was a
no, you were
vocalizing
looking at it like,
vocalizing
no, you
astonishment.
got it wrong. That's how you were looking at her. So I wanted that to go ahead and see how that worked for you.
Yes, Your Honor, my client was in lockup on Tuesday when I went to see him regarding this case. We were asking for an adjournment for mitigation purposes.
You told him when his court date was.
I did say we had court this Thursday, yes, sir.
Issue for that its failure to appear.
Thank you, Your Honor.
Bond will be set in the amount of 10,000 cash surety. I don't know why I'm doing this. I will not issue that until the 4th, so you can try to find him.
Thank you, Your Honor.
Court does call the case People versus Stephen Ruggs.
Bailey Zenda on behalf of the people, Your Honor. Mr. Ruggs, could you state your name?
Stephen Ruggs.
Thank you.
At this time, Your Honor, Mr. Ruggs is requesting that the court,
Okay, it's all discovery complete.
yes, to our knowledge.
People have their witnesses available to 12.
Yes, Your Honor.
Preliminary examination in person will be set August 12, 2025, 9 a.m. That is before Judge Valvo. Bond will continue.
All right, thank you, Your Honor.
Thank you. Court does call the case of the People versus Christopher Kniper.
Bailey Zenda on behalf of the people, Your Honor.
Apologies, Your Honor. Assistant Public Defender Jay Bellinger on behalf of, but not with Mr. Nieper. Your Honor, I have had a contact with my client as of yesterday, understanding that there's a bond violation in this case. He and I had a heart-to-heart. He is checking himself in, and I did show some form of proof to Ms. Zenda regarding his admittance to Bear River.
And that's correct, Your Honor. I did see that verification.
So is he in and headed up there?
He's already up in Traverse City, Your Honor.
So they've already taken him.
They will be taking, he's in that process. He's a day away from it, is my
Stay
understanding.
away from the Bear River.
Yes, Your Honor.
So what would you like me to do?
Your Honor, I would ask for an adjournment at this time. I would ask for 2 weeks, just so that I can make sure that he's in, and that he sends us the admission paperwork.
Any objection from the people?
No, Your Honor.
Probable cause conference August 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Case People versus Barrage Scott.
And Assistant Public Defender, Shannon Perry, Your Honor, on behalf of the Barrage Scott, who is approaching. Mr. Scott, when you reach the podium, could you state your name for the record, please?
Yes. Razante Scott. All right. Did you hear me?
Yes, I can hear you.
Okay, I'm sorry.
No, it's okay.
Judge, we are requesting an adjournment today.
Okay.
It's my understanding that Mr. Scott is going to be arraigned on Monday. Arraigned on I think it's an older charge that was just authorized. Did you confirm that?
I didn't see. I don't know where that is.
Well, Judge.
Maybe when I look over, I think maybe there's.
So another felony?
Yeah.
That's my understanding, Judge.
So, and if he's arraigned on Monday, the 4th, and he would get the 14th. Okay. So let's adjourn these out. I'll wait for the green sheets.
Okay.
But let's do August 14th, 2025. And if he does get arraigned on Monday or sometime in that week, they'll set it for the 14th. If you could note, so he doesn't get 2 dates, just to have whoever the arraignment attorney requests at the magistrate set.
Absolutely, Your Honor. Thank you very much, Judge.
All right, thank you.
I'm not gonna see you.
Bond will continue in both cases. I mean, yes. Is that her?
I didn't receive anything.
What did she say? For? That girl's gonna show up. This is my last. Out. Court does call the case, People of the State of Michigan versus Savannah Bradley. Recall.
Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
And Laura Yagi, Assistant Public Defender with on behalf of Ms. Bradley, who's approaching. Ms. Bradley, can you state your name for the court?
Savannah Bradley.
We have her test results.
We do, Your Honor. And it does look like the only positive is the amphetamine, which I think would be consistent with Adderall usage. Every single day she takes her Adderall. I know there are numerical values for some of the other substances. However, the outcome is listed as negative. So
It doesn't meet a threshold. I understand how that works.
So I would ask the court to, and I have had a very real conversation. Ms. Bradley, in all candor, was very terrified of being arrested in court today, and she came to court knowing there was the violation report, knowing the likelihood and possibility of arrest. And we had a conversation about that. She understands how serious it is to call community corrections every day and text. And she is very interested also in seeking help. So that's something that we're working on together. So I would ask the court to continue her bond and adjourn the PCC.
During the PCC to the 14th, 2025, 9 a.m. It won't. Did you get yourself enrolled?
I'm
When you were over
I can today.
today? They enrolled you?
Wait.
So did they give you like a color?
Oh, no, sorry.
Okay, we may need a new order. So you need to go back over there. I'm gonna prepare a new order so that you get yourself enrolled and that you do then, as Ms. Yagi is indicating, call them every day and follow their instructions. You understand that?
Yes.
Why did I put that? Okay. Bond will continue.
Thank you.
Thank you.
Court does call the case People versus Marina Sexton.
Bailey Zinn on behalf of the people, Your Honor.
All I have is.
Yes.
To do this.
Thank you, Your Honor. Costin Bilbese on behalf of Marina Sexton, who's present to my right. Can you state your full name, Marina?
Marina Sexton.
Thank you.
Your Honor, we're going to be requesting an adjournment for Padilla reasons, as well as to continue negotiations with the prosecutor's office, and I'd like to address bond when appropriate.
Yeah, you can. I'm gonna. Okay. Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Yes, go ahead. Esteban.
Yes, Your Honor, I'm going to be asking for a PR bond for my client. Your Honor, my client has no criminal history. She's been in for 11 days. She's currently pregnant. She also has been served divorce papers while she's been in jail that are related to this case. She wants the opportunity to be able to seek counsel for that. She's willing to go on a tether. She's even willing to submit her passport for the court to hold if they deem that
Counsel
appropriate.
approach.
Together. So I'm asking for an adjournment. I would not frankly know how long, maybe a couple weeks, but I don't know if it'd be accomplished by then or not.
Here's what I'll do. So that I'll put him out to August 19th at 9. So that if it does get arraigned, put it on the fourteenth, from the fourteenth, we can move it to the nineteenth.
Sounds good.
Be with this one, all right, I guess the only thing is if it gets set for the fourteenth, then we'll just kick it out to that day, okay?
Thank you, Your Honor.
Bond will continue. Court does call the case People versus Derek Stevenson.
Morning, Your Honor, Jacob Kennedy for the people.
How you doing, Your Honor? I'm doing well. Yourself? All
Mr. Gaddy.
Assistant Public Defender Tanazi Carey, I can really, on behalf of Mr. Derek Stevenson, for Mr. Mike Gaddy, Judge. I apologize, Mr. Gaddy just told me. How you doing, Mr. Stevenson?
How you doing? All right, you're requesting an adjournment.
We are, Judge.
Probable cause conference, August 14, 2025, 9 a.m. Bond continue.
Yeah.
Thank you.
Thank you. And get a seat at the table. Slow, in custody, they're not there yet.
No.
So who's wasn't told to launch? People were floating around. Just saying. What'd you hear? Why, you know what? Calls case, People versus Fred Willis.
Andrew Schultz appearing on behalf of the people. We're ready. Jake Kennedy appearing on behalf of the people, 18337 on matter, Your Honor.
Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Willis. Mr. Willis, please state your.
Fred Willis.
And I believe that will be, well, we still need additional discovery. I believe that's already been requested. So there'll need to be an adjournment in this matter.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m.
Thank you very much, Your Honor.
Bond continue. Let's call the case of the People versus Douglas Wren. Oh, wait, I'm sorry.
For Yaki, Assistant Public Defender, with and on behalf of Mr. Wren, who's approaching. Mr. Wren, can you state your name for the court?
Douglas Allen Wren.
Requesting an adjournment.
Yes, Your Honor.
So there's a question about his participation.
So he's in recovery court, but by
the no license charge, okay?
Thank you.
So actually, there's a plea on file B, Amy. I'm making it 150. And then file A is dismissed. Excuse me. You're all set. Good luck. All right. What do I have? Did we call Jessica Robinson? Call her if you would. Rajwinder Kaur Shahal, 25T645897. All right, come on up, ma'am. Your name? You have a valid license. Was that valid then?
Yes.
Yeah, and the ticket so indicates. You're gonna plead to impeding traffic, they're gonna dismiss the misdemeanor, right?
Yes, sir.
I'm just gonna go light on you, $85, okay? $85, you go down the hall and pay that, you're all set. The original charge dismissed. Best of luck.
Thank you, sir.
Maya and Nicole Bailey here. Who's your lawyer today?
Dave. Mr. Gay?
Yeah. But let me, tell him 5 minutes. I'm gonna do this Robinson case first. You can have a seat right at the table behind you. Napoleon Chevalier Robinson, 24F24337. And I need Jessica.
Good morning, Your Honor. I'm here against my client, Joseph, same sign you left.
Sir, your name?
My name is Napoleon.
How is he going to proceed?
Your Honor, I talked to my client regarding a violation of probation hearing. That won't be necessary. He's prepared to admit a violation.
Is that right, sir? Okay, nice and loud for me.
That is correct.
If you plead guilty, you could get 5 days on this. That's the maximum pursuant to law. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
I understand.
The charge, you failed to refrain from consuming alcohol, testing positive on a chemical test on July 9 of 25 for alcohol. How do you plead on ETG?
Guilty.
Did you drink alcohol within the 3 days before that?
Yes, sir.
Anybody force you to plead guilty?
No, sir.
And you acknowledge that your test came up positive, correct?
Yes.
I'll accept your plea. I find it to be an accurate plea. Talk to me. Your name?
Jessica O'Donnell on behalf of probation.
Mr. Robinson. I haven't seen Mr. Robinson in a month or so. I like Mr. Robinson. You just can't stay out of here, though, Mr. Shemke. He likes me. He wants to come see me.
I can't blame you, Judge.
What's he doing? Tell me something positive.
He's compliant. He's compliant with his payment plan. He owes a little bit of a balance, $455, but he's compliant in his payments. He paid off his other case. He has completed his victim's impact panel on this case. He completed all his court work or his 8 hours of community service. Just with the testing though, he was ordered just on-demand testing. I would just ask moving forward, Your Honor, that he put on more of a schedule of testing, like bi-weekly testing, just so we can have more of a set testing for him.
And he's on probation for 12 months or until February.
Yes, and then he has another case that he's on probation. He's set to be discharged in September on
Is
that
that in
case.
front of me?
I believe so, it is in front of you.
He always draws me, doesn't he?
Yeah, that case, he doesn't have any alcohol or drug related on that one, so that wouldn't be a violation on that case, but he's completed everything on that case. That case is paid full, anger management completed, 16 hours of community service done, 3 days in the court work program. He's all set. All he's got to do is stay out of trouble on that case and he'll be discharged in September.
Anything else?
I believe that that's an accurate summary, Your Honor. Nothing further.
Anything else, sir? Do you want to say anything?
No, sir.
The additional cost is 75. Test bi-weekly for 3 months and then monthly. She's going to set you up on a new color. You're to serve 8 hours of community service by August the 25th. 8 more of this hours of community service. Don't do this again, okay?
Yes, sir.
You have the $75 or you need time?
I have, well, it's on my card, but not cash, but I have it.
You can pay on your card?
Yes, sir.
Okay, so pay that now. She'll talk to you about your new color and you get the community service done by the date I gave you and you're all set.
Thank you, sir.
Thank you.
Good luck.
Thank you, Judge.
Is Dylan Ford here?
Yes.
Dylan Ford's here. How about look, do we have Mr. Gathan here yet?
I called him around, says on the way.
How about Lolita Nichols? Lolita Marie Nichols. 25T6458988A and B. How you doing, ma'am? Sounded like a positive remark. What's your name?
Lolita Nichols.
You met with the prosecutor.
Yes, I did.
You negotiated like a seasoned lawyer. They're gonna plead you to no ops and avoid traffic control device, and they're going to dismiss the suspend and disobey traffic signals, so you're saving a point. And is that what you want to do?
Yes.
If you plead to avoid traffic control device, that's a 2-point civil infraction. If you plead to no ops, that is a misdemeanor punishable by up to 100 fines, 90 days jail, costs are all those. Do you understand that?
I did.
And did you sign, read, and understand the advice of rights form here today?
I did.
If you plead guilty, you'll be giving up all those rights, and there is not going to be a trial of any kind. Do you understand that?
I did.
All right. You have the right to a lawyer. If you want one, I will appoint you one. Do you understand that?
Yes.
Do you want a lawyer?
No.
To the charge, no valid operator's license on person, how do you plead?
Guilty.
To the charge of avoid traffic control device, responsible or not responsible?
Responsible.
I'll accept that plea to avoid traffic control device, disobey traffic signal charge dismissed. I'm going to listen to anything that you have to say before I sentence you, and I'm also accepting your plea to no ops and dismissing the suspend. Anything?
Yes, I'll be getting, I can't get my license till next year.
I saw that.
Okay, so that's basically it.
You can't drive them,
Okay,
okay?
I got you.
I know you're going to say that and then still drive. You can't drive. You're going to get yourself in trouble, please.
Yes, sir.
Fines and costs on the avoid traffic control device are 160, on the no ops, 50 fines, 50 costs, 75 victims' rights, $50 justice assessment, 225 or 45 days, you pay 390 and we're done. You have all that?
I can pay.
385.
Pay 200, okay.
Okay, you pay that one. You're gonna pay the avoid traffic control device now, so that's 160, so you'll then pay 40 on the no ops, and I'll just give you until August 25th to pay the rest. That will leave you a balance of 185. Can you do that?
Okay, yeah, so I'm paying $200 today, and then I pay the
The
rest.
remaining balance of 185 by August 25th.
Yes,
Can you do that?
yes, I can.
If you can't do that because something happens, I get it. Life gets in the way, you call the court, we'll go on Zoom or walk in here on or before the due date, better yet, at 8:30, I'll give you all the extensions we need to give, okay?
Okay,
Good luck to you.
thank you.
Maya Bailey, Maya Nicole Bailey, 25G306372B.
Good morning, Judge. Madam Clerk, Matthews Bailey. Bailey, state your name for the record.
All right, so your client
Yes, sir.
pled guilty. Just give me 1 second. Can you pull up this file, please? All right, so your client pled guilty to aiding and abetting a minor.
Correct. Pursuant to Hyatt.
I get it. You had a chance to review the report with her, and are there any material additions, corrections, or
We
deletions?
had a chance to review the report, Judge. It's actually accurate. There were no corrections, omissions, or deletions.
She actually pled no contest, right?
Yes, Judge.
Yeah. All right, what would you like to say on her behalf?
Judge, just that Ms. Bailey,
I know. Go ahead, go down.
she's 23 years old, Judge. I mean, she's gainfully employed. She does work with autism behavioral group. And you are studying to be a nurse, correct?
Yeah.
She is studying to be a nurse. Judge, she's a single mother. She has a 16-month-old daughter at home. She's got no prior criminal history. This was obviously out of character for her.
Why was she involved in this to begin with?
The altercation was with my brother,
And, we lost our
Okay.
mom in October and the kid was like really bullying him bad. And what he said to my brother was completely uncalled for. So my brother was originally gonna fight him and I just went up there to pick him up from school basically, so he didn't have to ride the bus home. But then it just got way out of hand.
You're supposed to be the adult in the group,
I know.
okay? You guys can't be encouraging people to fight that are in 8th grade.
I know, I think my feelings just got way over my head.
Well, you seem like a nice lady. You never been in trouble before?
No.
All right.
We're asking the court to adopt the recommendation sentence for the 6 months.
Given the nature of how old your child is, there's no reason for you to go to Shoemate Middle School, right?
No, he's gonna go to Carlson. He's going in 9th grade this year, so.
I mean, I see that you pushed the kid according to the report. They didn't charge assault and battery here, or at least you weren't convicted of that. They dismissed it, but why does everybody want to fight now? Huh? We got crazy people walking into buildings with assault rifles. We've got people shooting one another, killing one another. I don't get it. But this is the kind of thing that bothers me, and I'm dead serious about this. You can't be encouraging violence. There's other ways to handle this. The kid might have acted like he should not have acted. He might be bullying people, and that isn't right either. There's a mechanism. Somebody's doing something wrong, you go to the police, you let the court system take care of it, or in that case, maybe have gone to the principal, right?
I think it was just a heat of the moment.
I get it, but I don't think your conduct was quite as bad. I'm gonna do 6 months probation. I'll take it under HIDA. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'm gonna order the anger management weekend program. You're not to have any contact with the victim or his family members. 2 days of community service by September 15th. You can't go back to Shoemate Middle School. Again, you cannot leave the state, cannot violate a law. You must appear in court as directed at probation. You have to report as directed. So again, weekend anger management, no contact with the victim or his family members, 2 days community service by September 15th. You're not to enter Shoemate Middle School. I'm not going to order the impulsive behavior program. Fines 100, costs 175, victims' rights fee $50, justice assessment for 3 1/4, screening fee 60, for 385, court work program fees. I'm sorry, probation fees of 120 for 505, attorney fees of 40, your total's 545. You pay that, you stay out of trouble, we'll give you a review hearing date. You come back, and I'll be more than happy to dismiss this case for you, okay?
She'll require a payment plan.
That's fine. I hope you're, is the father in the child's life?
Not really.
Is he paying child support?
No,
Why not? Why aren't you going after him?
it's not worth it.
He doesn't work?
Not really, no. We're in a domestic relationship, so I just kind
You're what?
of, we were in a domestic relationship, like, he would beat me.
Domestic violence.
Don't let him do that garbage.
Yeah, so that's why when I got pregnant, I just kind of, I didn't care about child support, none of that. Yeah.
Boy, these guys out there, I don't get it. What kind of a man does it take to beat up a 5'2" woman? I got to tell them, yeah, they ought to go pick on UFC champion or whatever. Heavyweight champ. I mean, I'm serious. I mean, it doesn't take much of a man to do that. I'm gonna let you pay $25 a week. 25 per week. And I'm gonna start this August the 8th. You think you can do that?
Yeah.
Judge, if Miss Bailey was to complete all her requirements.
Yeah, she can talk, you can talk to the prosecutor and they can move for early discharge and get the prosecutor to move to dismiss. And I don't have a problem with that. All right, what do we have here for a review hearing date? It's gonna have to be latter part of January.
We can do January 22nd.
22nd at 8:30. All fines costs due by then, okay? So if you can pay more, great. If you can't, I understand. If you need more time, call the court. We'll go on Zoom. I'll give you an extension. Don't let men treat you that way, young lady. Ever. I hope you called the police. I don't want to know. Good luck.
Thank you.
Dylan Randall Ford, 25G306-475.
Good morning, Judge. Magistrate Attorney Mr. Ford.
Mr. Ford, your name?
Dylan. Full name. Ford, Dylan Ford.
How you doing today, Mr. Ford?
Good. Judge, today's the time set for sentencing in this matter. We got a chance to review the pre-sentence report. We've got no issues, corrections, or deletions. Judge, are just factually accurate.
There's concerns when somebody can't drink and they're doing it. Right? You can't legally drink yet, right?
Correct.
Why were you drinking? You don't have to answer that. All right. Counsel, seems like a nice kid. He did a stupid thing. I hope he's learning from it. What else would you like to say?
Judge, just that Mr. Ford is gainfully employed. He is a welder. So he does have a good future in front of him, Judge. And he has no prior criminal history, Judge. This is the first offense for him. Obviously, he understands what he did is wrong and he can't be drinking at his age anyway, like you stated. I've spoken to him. He's told me that he's trying to turn his life around and kind of make better choices, Judge. So we asked the court to take that into consideration in assessing or.
Seemed like a really nice kid, man, but
He's a nice kid, Judge.
I can tell.
And I know he said.
I remember him from before. Respectful.
I know he said he wants to address the court, Judge.
Go ahead.
Yeah, I just want to apologize for any disturbance I caused, you know. I didn't grow up in an alcohol family. I just got involved in it, so I'm trying to, I do regret it, and it was a mistake, and won't happen again.
Your parents were here initially last night.
Yeah, they were here.
And then they left before the plea, right?
Yeah.
What happened? Why'd they leave?
My mom had work,
Okay.
and,
Well, look, I just remember that. I thought that was good your parents came. Shows they're taking an interest still. You're only 20. You should listen what your parents say till you're 80. I'm serious. And that was good. Now, look, we all make mistakes. I want you to put this behind you, but I want you to figure out a way to go forward with your life.
yes, sir.
You got a good job. 10 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Marijuana, illegal drugs, or alcohol. Submit the chemical testing PBTs and ETGs bi-weekly for 8 weeks. If you're clean, I'll then make it monthly. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to be in outpatient treatment by August the 21st. So you got to get going on that. Get yourself an outpatient. You'll go over all this with probation. You're to attend the Victims Impact Panel. You're to serve 2 days on the court work program, pay $70 for that, $35 per day, and serve 1 day of community service by September 1. 300 fines, $225 costs, 75 victims' rights fee, $50 justice assessment. So fines and costs are $650. Probation fees are $200 for $850. You have a screening fee of $60, and you have $40 in attorney fees for $950. Then you have cost of recovery of $150 plus your court work program fees. Everything included is $1170. If you violate, your probation could be revoked. You could be incarcerated for 93 days. With credit for 1 day served. So it's 4 days jail credit, 1 served, 3. And again, you can do those 2 days court work in lieu and 1 day community service in lieu of jail. You get all this done, you pay your fines, you stay out of trouble, you can come back here in 5 months and ask for early discharge. And by law, you're entitled to it. Do you understand everything I've said?
Yes.
You have 21 days to appeal and 14 days to apply for a court-appointed lawyer for purposes of appeal. Can you pay all this down?
Yeah.
You got a good job. Good for you. Stay out of here. You don't belong in here. Good luck.
I may have missed it. What's the deadline to complete the court work and the community?
Court work, they're gonna schedule them. Community service by September 1, 8 hours by September 1. He can do that, of course, as you know, at any nonprofit. Okay?
Thank you.
Good luck, sir. And you'll meet with probation then before you leave. Best of luck.
Thank you, Judge.
Thank you. Do you have another one for me?
I've got 3 more files. Give me about 15 minutes.
Okay, good enough. Do these people, are they ready to have their case called?
That's actually one of mine, Judge. We're just gonna ask for an adjournment on this match.
Okay, well, let's do that and get her out of here, poor lady.
I'll grab the file.
Oh, okay. I don't want you guys having to wait too much longer than you. Tabitha, do you have anything else?
I have nothing right now. We have no shows. Do you want to do?
A and B, A and
Sergeant Essick ordered John to stop running prior to tasing him, which John disobeyed. Detective Vespremi interviewed John, who denied placing the camera and denied entering the women's restroom. Despite being told of the surveillance footage, he claimed he was at Panera to use the free Wi-Fi. He claimed he ran because he thought the officer was an ICE agent, even though he was not a legal immigrant. When shown the pen camera, he says he's never seen it, but it looks like a device that he was previously accused of using in a separate allegation. He alleged he's being set up and maintains his innocence. John is currently out of police custody.
based on your sworn testimony, I find the crimes of assault, resist, and obstruct, eavesdropping, or installing or using a device and capturing or distributing, attempting to capture or distribute or otherwise distribute an image of Kylie Magyar. I'm going to go ahead and authorize the issuance of complaint and warrant. You signed the complaint, I believe, yesterday, so I'm going to go ahead and change the date to today and initial it. I'm signing and dating the complaint and the warrant for the arrest of the defendant. You are all set. Have a good day. Thank you.
Thank you. You as well, Your Honor.
David Ronald Sertage, 25B714630.
He's not ready for that. He's downtown on trial. He can't do that now.
Oh,
Brownstown can't do that.
okay.
I'll just hang on.
Yeah. Let's take this off. Do you have anything else ready here? No, he speaks Spanish, and I was trying to explain. No insurance. Is that what you want to do, Mr. Parkhurst?
Yes, Your Honor.
All right, he's got everything up to date now?
Yes.
So, sir, to the charge of no plate, the civil infraction, responsible or not responsible?
Responsible.
And you understand I'm going to dismiss the misdemeanor driving an unregistered vehicle and also no proof of insurance, right?
Correct.
And you've got insurance now?
Yes.
Okay. I'll accept your plea, dismiss the original charges, the misdemeanors, $150, fines and costs. You can go down the hall and pay that. Have a good day. Good luck. Gabriel Grace Hash, 25G306488.
Good afternoon, Judge Mazengate, your Daphne Smash.
Ma'am, your name?
Gabrielle Grace Hash.
How are you?
How are you?
Good. We're going to adjourn this?
Yeah, just 2 minutes, Judge. We're waiting on some additional stuff.
Okay. What do you want, 2 weeks?
2 weeks.
August 14th, Amy, at
9:45.
9:45, okay?
Perfect.
Is that perfect? Okay. just want to make sure you're good with the date. Go down the hall, get your notice. You're all set. Have a good day. Jason Richard Welsh. 25T645761.
Good afternoon, Judge Matthew Gates.
How you doing there, sir?
Good, Your Honor, how are you?
Not too bad. You're gonna plead to allowing an unlicensed driver to drive, correct?
Yes, sir.
They're then going to dismiss the suspend. Is that what you want to do?
Yes, Your Honor.
And you got a valid license now?
I do.
If you plead guilty to allowing an unlicensed driver to drive, the possible penalties are up to 500 fines, 90 days jail, costs of all those. Do you understand that?
Yes.
This won't get reported to the Secretary of State. Do you understand that?
Yes.
Did you sign the advice of rights?
I did.
Did you read it?
I
Did you
did.
understand it?
Yes.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, Your Honor.
Do you have any questions?
No, sir.
All right. The charge, allowing unlicensed driver to drive, how do you plead?
Guilty.
On June 12 of 25, were you operating a motor vehicle on Grange near King and Trent?
I was.
And were you suspended at the time?
I was.
And are you on probation or parole?
I am not.
Anybody forced you to plead guilty?
No, sir.
What are you, 27?
Yep.
What are you doing?
Flooring, carpet.
Good.
Tile.
I'll accept the plea. I actually, when I first got married, well, after a year or two, we moved over by you where you live now. I'm not gonna say it. I don't want. I'll dismiss the suspend. Anything? He's got a valid license now.
He does, Judge, and he made efforts to take care of it before it's running out. We asked the court to take that into consideration.
Sir, anything that you want to say?
No, Your Honor. It shouldn't have happened and I will not happen again.
100 fines, 75 costs, 75 victims' rights, $50 justice assessment, 40 in attorney fees. Your total's $340 or 30 days. Can you pay that today or do you need time?
I need some time, Your Honor.
Do you have any money today?
I just paid
That's
$275
fine.
on another ticket.
You pay 75, can you pay 60 per week?
Yes.
Can you start that August 8th?
Yes.
That's your plan. 60 a week starting August 8th. If you don't have the money, it's not a problem. Call the court. We'll go on Zoom or come up here on it before your due date, 8:30. I'll give you an extension.
Thank you, Your Honor.
Fair enough?
Fair enough.
Good luck.
Thank you very much.
You have one more?
We have one more. She was sitting in here. Apparently, she didn't check in with the court officer. So I had an officer come and grab her. So we're just working out the final few minutes, Judge. I'll leave that.
Okay, good enough.
Cases out there.
Sir.
Plead to impeding, that's 0 points. If you plead to allowing an unlicensed driver to drive, that's 0 points. That is punishable by up to 500 fines, 90 days jail, costs are all those. Do you understand that? And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, I do.
To the charge allowing an unlicensed driver to drive, how do you plead?
Guilty.
And to the charge impeding traffic, responsible or not responsible?
Responsible.
Were you in control of a motor vehicle that was being operated in the city of Trenton, county of Wayne on West Jefferson near Harris in June 11 of 25?
Yes.
And you were operating that vehicle without a valid license, true?
Correct.
Are you on probation or parole?
No.
Anybody force you to plead guilty? That plea is accepted. The suspends, the driver while unlicensed is dismissed. Please accepted to impeding. I think I asked you, but I'll ask you again. To the charge of impeding traffic, responsible or not responsible?
Responsible.
That plea is accepted. Disobey traffic signals dismissed. Does she have a valid license now?
She's got a restricted license.
Let me see here. Uh-oh. OWI.
Valid restricted license.
Oh, did you go and get,
I could go to the Secretary of State, yes.
okay. All right. Anything else, counsel?
Judge, just that, Ms. Brown understands that she needs to be more careful next time and only drive when she is authorized to drive by the restrictions placed on the license. I just understand she made a mistake and sure that's not gonna happen again.
Anything, ma'am?
No, I just moved to this area and I did not see the light that was there, so that was totally my,
All right, on the allowing a licensed driver to drive, 100 fines, 125 costs, 75 victims' rights, $50 justice assessment. So your fines and costs here amount to $350, 40 in attorney fees, $390 or 60 days plus. On the impeding traffic, the fines and costs are $170. So your total here amounts to $560. Can you pay that?
not today, but I can make payments on it.
Do you have anything today?
No, I get my paycheck, I actually get my paycheck today, it should be in the mail when I get home.
Do you work? I mean, do you get paid weekly or bi-weekly?
Bi-weekly,
How much do you make bi-weekly?
about 800, I bring home about 800 bi-weekly.
I'll tell you what, you pay $75 bi-weekly. We'll start it on the civil infraction. You'll start that beginning August the 4th, okay? That's Monday. And then you can go and pay your other charge, the allowing a licensed driver to drive at the rate of $75 bi-weekly. And you'll start to pay those after fines, costs paid on A, okay?
Okay, that's good, thank you so much.
Do you have any questions?
No, sir. Oh, yes, I could.
Please.